Hold on, I'm just going to interrupt you because this press conference is starting with the Attorney General of the State of Washington. Let's listen in.
Good afternoon, everybody. Thank you so much for being here. I'll say a few words, followed by Noah Purcell, my Solicitor General, followed by Colleen Melody, who is the head of our Wing Luke Civil Rights Unit, and then we're happy to take your questions. For those on the phone, we'll try and get to your questions after we take some from the room. Bottom line, this is a complete victory for the state of Washington. The Ninth Circuit Court of Appeals, in a unanimous decision, effectively granted everything we sought. We are a nation of laws. And as I've said, as we have said, from day one, that those laws apply to everybody in our country. And that includes the President of the United States. We've had a chance to take a look at the opinion. And one thing I just want to mention before I turn to Noah, then we'll take your questions, is throughout this litigation, the President has asserted that his actions in signing this executive order are unreviewable. And you heard the question posed by the Ninth Circuit judges in the oral argument this week. The question was asked, is it the view of the Justice Department that those actions are unreviewable? And after a rather lengthy pause, the answer was yes. Here's what the Ninth Circuit had to say about that. There is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy. I'm so proud of our team. As many of you know, they've been working literally around the clock on behalf of the people of the state of this, on behalf of the people of this state. It's the folks you see here who will be introducing shortly, but also attorneys and professional staff around our office, in different offices spread out across the state, all working in different ways to assist us with this filing, these filings which have been done under intense time constraints, as you might imagine. So I want to emphasize this has been a team effort from this law firm. It is a very proud indeed for this law office, and I couldn't be more proud of the teamwork that's been involved. With that, I'm going to turn to Noah, who will, I'll ask him to say a few words and also just to summarize essentially what the Ninth Circuit Court of Appeals did here today, and then we'll have a few words from Colleen. Noah?
Thank you, Bob. What we argued to the court yesterday was that it's the role of the courts to say what the law is and to serve as a check on the executive branch, and that's what the court has done in this opinion, in this excellent opinion, this well-reasoned, careful, thoughtful opinion that seriously considered all of the government's arguments and rejected them. And it's important to recognize the real impact that this has already been having on people's lives. We've just been hearing from people all over the state and all over the country about what a difference this has made, and we're so thrilled for that. And I want to thank Attorney General Ferguson for having the bravery to bring this case in the first place and to authorize us to do all this. Thank the governor and the people of the state for all their support in bringing this case, and most especially I want to thank the people across our office, as the Attorney General was saying, people in my office like Ann Eagler, Kelly Paradis, Kelly Wood, Kristen, Wendy, anyway, I'm going to forget people, but the bottom line is we have an outstanding office here in the AG's office. People do public service every day. We're not usually in the limelight like this, and we're not really used to it, but we're proud to have been able to play this role. Just briefly about the opinion, it is, as the Attorney General said, a complete victory. It upholds the district court's injunction in every respect. And we couldn't be more pleased with how careful and thoughtful the opinion is. The judges did their jobs carefully and well, and we appreciate their work and thank them for the careful attention that they gave to this case. That's all I'm going to say for now. I'll turn it over to Colleen.
And so, no, I think I mentioned, of course, is our Solicitor General who argued at the hearings before Judge Robart at the trial court level and at the Court of Appeals. And one thing I appreciate is the fact that this case has had there's been an opportunity for the public to see people who work on these cases, folks like the team you see here today, and Noah's a brilliant lawyer. He's doing an excellent job leading this team. Next, I want to introduce Colleen Melody. Colleen is the head of our Wing Luke Civil Rights Unit. I created that unit a couple of years ago, 2 years ago, and as you may know, up until then, if somebody called our office with a civil rights complaint, despite the fact that we have close to 600 attorneys, we did not handle civil rights complaints on behalf of the people of the state of Washington in an affirmative way, which struck me as something that need to be remedied. So we created a civil rights unit. You're seeing folks who Colleen will introduce who are part of that team. And while I did not anticipate at that time that the magnitude of a case like this, where that team would be pressed into service, I'm so glad and proud that we had a team of excellent attorneys and excellent professional staff in that civil rights unit who have the background, the expertise, and the work ethic, who really were prepared for this moment in time to bring this case to the successful results we've had so far. So Colleen Melody, last name spelled M-E-L-O-D-Y. Colleen.
Thanks, Bob. So I'll pick up sort of right where he left off, that from the beginning on a early Saturday morning when we started talking about how we were going to respond to this case, the people on my team recognized it instantly as a basic fairness, social justice, and civil rights issue. And so I'm very proud of them for stepping up to sort of do whatever was necessary to help get this result that we're talking about today. So I wanted to introduce Marcia Chen, who's an assistant attorney general on our civil rights team, Patricio Marquez, who's on the end there, Mitch Reese, who's over here, and Shalia Stallings-Ala-Ilima, who's in the
All
back.
right, we're going to keep monitoring this, and we'll go back in as needed. You did just hear, though, the Solicitor General who led the team, Noah Purcell, and the Attorney General for Washington, Bob Ferguson, speaking there. Alan Dershowitz, you heard the Attorney General. He said, basically, we got everything we wanted. And then they went on to talk about how well-written and fantastic this is. Of course, in their view, it absolutely is. They did get everything they wanted.
Yes, they did, but it doesn't mean they're going to win ultimately on the merits. They still have a very, very uphill fight to persuade the Supreme Court that A, the state of Washington has standing, B, that you can apply the Constitution to people who have never been in the country, who are simply seeking a visa for the first time. Look, there's a way around this that's a win-win for everybody. The president has lost, so he is now in a state of limbo for weeks, perhaps even months. His order is going to be stayed. He claims that this is a threat to the national security of the United States. If he's right, then he has only one option: rescind the order, start from scratch, write a new order with his new attorney general, with the cooperation perhaps of members of Congress, that will both protect the security of the United States and avoid constitutional challenge. That's his best option right now. But it would require him to admit he was wrong. So now there's a clash between the ego of the president and the national security of the United States. And he has to resolve it in terms of the national security of the United States by rescinding this state order and coming up with an order that won't be stayed. Right. That's what he ought to do.
Well, it's pretty important how you put that, because, Ariane, what Alan is saying is that the president says this is so crucial. If this was so urgent and crucial for security, right, he would say, okay, forget it. I'm going to throw this out and write a new one, and that's going to be done perfectly, and it's going to go into place, and there's not going to be an issue. But he's already tweeted out in all caps, see you in court. He's going to fight over the one he already did.
Exactly. And he said, the DOJ hasn't responded, but he said, I'll see you in court, and maybe that means the Supreme Court. But I have to say one thing about this opinion that I think is so interesting. Remember during oral arguments, and Judge Friedland asked the government, she said, is this unreviewable? And then there was this long pause, and the government said, yes. And that sure didn't sit well that night. And tonight, it's the strongest language, I think, in this opinion. They wrote, there is no precedent to support this claim of unreviewability, which runs contrary to the fundamental structure of our constitutional democracy. That is really strong language, and you can see that it bothered the judges during oral arguments, and it's reflected in this opinion.
All right, so you mentioned that moment, and I want to read what this court has ruled on that issue, this unreviewability. But that moment when August Flenchie, who is the career justice lawyer who made the case, Paul, when he argued this, I just want to play for everybody. When the judge said, are you arguing then that the president's decision is unreviewable? Here's exactly how it played out.
Are you arguing then that the president's decision in that regard is unreviewable?
Yes, there are obviously constitutional limitations, but we're discussing the risk assessment.
Okay, that was the painful pause, and that became a core of what we're seeing here. They are citing, Paul, a 1967 case saying national defense cannot be deemed an end in and of itself. It would indeed be ironic if in the name of national defense we would sanction the subversion of one of those liberties which make the defense of the nation so worthwhile. They're citing a previous case. They're saying absolutely not. The president's decision on this is reviewable, completely rejecting that argument.
Oh, and this is critical because this whole battle was the president saying, I'm the only one who's in charge of national security under the Constitution of the United States, and local judges have no right to interfere in my decision-making. And here, they throw that concept in the judicial trash barrel and say, essentially, we can review even national security issues. You don't have exclusive authority in this area.
And the cases they cite to make that point that no national security issue is above the Constitution are the Guantanamo cases. The cases where the Supreme Court said to the Bush administration, you have to abide by the Constitution, even when it involves terrorism, even when it involves some of the worst people we've ever encountered, and even when it's in Cuba, where Guantanamo prison is, not inside the United States. So the idea that national security decisions are somehow outside the review of the courts is one that's been rejected again.
If you get back to the standing issue that Professor Dershowitz had talked about earlier, this is such a sweeping decision. They essentially say that because aliens, and that's the term used in the statutory wording, from other places who normally don't have rights under U.S. law, can be represented by the state of Washington because some of them are students or maybe could be students in the state of Washington. It's a broad grant of standing and U.S. constitutional rights to people in other countries.
And Alan, there was a compromise that was during the oral arguments we all heard. August Flinchy put forward a compromise, right, that would have said, well, this only applies to people who've never been to the United States before, sort of giving them an out, right, for things like green cards or already granted visas. They also very explicitly here say they're not buying that either. I mean, they didn't give them a millimeter.
Well, I think they were right not to buy it for purposes of the stay, because to undo the stay now would have created chaos, especially if they have to 2 months from now or a month from now reinstate it. But I think when the case gets to the Supreme Court, Chief Justice Roberts is very, very tough on standing. He has used standing often to avoid reaching these kinds of difficult constitutional issues. And this is the most extreme case of standing that I have ever seen in my 53 years of appellate litigation, having the state of Washington have standing to assert the rights of people who have no contact with the United States, that have never been in the United States. There are two possible ways of making that argument. One, as an establishment of religion, where, remember, the Constitution doesn't just grant a right there. It says Congress shall make no law. It's a restriction on the federal government. That's one way of doing it. Yep. The other way of doing it is to say that, look, we really have an interest, our tax base, our students, et cetera. It's going to be a hard row in the Supreme Court. There's no way of predicting the outcome of this case on the merits if it gets to the Supreme Court.
Laura, what do you think?
Well, you know, what's so striking to me is the fact that the court does concede that the President of the United States could get deference when it comes to national security. But the reason national security interests were a paramount concern to this particular court is because of procedure. Look, the lower court said we're going to suspend this ban. In order for this court to reverse that ban, they asked the Department of Justice to explain to them why returning to the pre-travel ban status quo of the vetting process would somehow hurt the federal government and its citizens. Tell us what you know. What is it about our new, perhaps novel national security risks that require us to go back to or have a new system of vetting? And unfortunately, they had no response. And that's also one of the main components of this order. The court is saying, we agree there is deference, although we can review it, and we did when it came to Japanese internments, and we did when it came to giving communists or denying them passports. But if you actually have a valid reason, now is the time to tell us. And now came and went.
All right, we just, as you finished speaking, got in the audio of the President of the United States responding to this. Let me play it for you. Here's Donald Trump.
This is just a decision that came down, but we're going to win the case. And have you conferred with your new Attorney General on this tonight? Is he
No, I
appointed now?
haven't. We just heard the decision.
How did you find out about the decision, Mr. President?
Just saw it. We just saw it just like you did.
All right, obviously a little bit of an issue there at the end, but that was his immediate reaction. Of course, he'd went on to say that he thought this was political. David Gergen is also here with me right now, and also with me, Mark Preston, our senior political analyst, Bill Kristol, editor-in-large of the Weekly Standard, and Kayleigh McEnany, contributor at The Hill, joining all of our legal experts. When you hear the president's response, saying that this is political, saying they are going to fight it, tweeting, "See you in court," in all caps, David Gergen, it's clear where he stands on this. He's not going to revoke the order and try to write a better one. That's not at least how he's talking tonight.
It's sure not, although Alan Dershowitz has a useful point. I mean, his whole notion, Alan's notion of repeal and replace, has some resonance here, and that may be the best way out for the president ultimately. But he is going to fight in the meantime. He's going to hurt himself if he continues tweeting and challenging the court and challenging the judicial system. But I must say it's a surprise to everyone just how broad and sweeping this opinion is, written by, including one judge appointed by George W. I mean, they rejected the standing argument. They rejected the reviewability argument put forward by the government. They said they rejected the argument that there was no likelihood of success. Citing Donald Trump is very important, citing what he's been saying all through the campaign, that he wanted a ban on Muslims, and that there's evidence, Rudy Giuliani's conversation, that this was the way to start down that path toward a Muslim ban. That's very important, seizing upon that in politics. And finally, they just rejected the notion that the administration has been putting forward, that this would do enormous harm to leave this in place. They just said, you haven't presented any evidence. If you'll present some evidence, we might be persuaded, but the government failed to do that. I think it was sloppily argued by the federal government, stinging defeat for the administration. We'll see where we go from here. Alan may be right. Ultimately, the administration may prevail on the substance.
All right, so let me just play. I believe we now have that full audio, and I want everyone to hear exactly what he had to say about the politics here. So here again, Donald Trump.
Decision that came down, but we're going to win the case.
And have you conferred with your new Attorney General on this tonight? Is he appointed
No, I
now?
haven't. We just heard the decision.
How did you find out about the decision, Mr. President?
Just saw it. We just saw it just like you did.
Via the news, et cetera, the media.
But it's a decision that will win, in my opinion, very easily.
And are you any
And by the way,
closer-
we won that decision in Boston.
Are you any closer to a Solicitor General who would speak on behalf of your
I'm going to be
government?
making a decision over the next week on a Solicitor General.
Okay.
Bill Kristol, you hear the president's response, and obviously he hadn't had much time to think about it. What's your takeaway? Because obviously the key thing here is just what